Welcome back to McDermott's Return to Work webinar series. I'm Mike Sheehan, and I'm going to be serving as your moderator today. Today's webinar focuses on the anti-return to work. With many employers delaying bringing employees back to the workplace until next year, 2021, and the Department of Labor issuing evolving guidance for remote work, we'll discuss strategies to help ensure you remain in compliance. Now, before we begin today's program, before I introduce you to the panel, I'd like to share just some logistical notes. If you have any questions during the webinar, please submit them using the Q&A feature, and we will address as many as we can before we conclude. We've got a busy agenda today, so if we're unable to answer your questions, we'll follow up with you directly. You can count on that. A link to the presentation recording and a copy of the slide deck will be available to you after the webinar. This program also offers CLE credit. It's important that you fill out the post-event survey that'll be emailed to you in order to include your required information for CLE. For those of you in New York, you're going to have to stick it out the entire program. I'll read out a validation code later at the end of the program, and you should write that down and enter that in the post-event survey. Recordings from the other 10 webinars in our Return to Work series can be found within our Return to Work virtual toolkit. It's available on McDermott's Coronavirus Resource Center. Now, without further delay, let's get started. I'd like to introduce to you our panel for today. Emery Moore, an associate in our Chicago office. Joel Mulheron, a partner in the Chicago office. And Michelle Strohiro, a partner in the Los Angeles office. Before we get started, and Joe, I think you're first up, let's poll the audience. We've got a question for them. So since our workforce has gone remote, our biggest wage hour concern is, and this is a question for you all, employees are working outside scheduled hours, employees are working through their meal periods, expense reimbursement claims, or none. You have no worries. Check the box. Let's tally it up. Now, what do we have here? Looks like it's over 50%. I've got 52% showing for employee. The biggest concern is employees working outside scheduled hours. Joe, is this consistent with what you were hearing about?
This is interesting because I think Michelle and I were talking about this before the presentation, and the most questions I'm receiving are on expense reimbursements. I'm actually happy that it's the employees working outside scheduled hours, because I do think that that's the area that requires the most attention. But these are, for those folks who are other or none, no worries. Hopefully you'll continue to pay attention to me. I will try to make wage and hour interesting.
And Joe, has the plaintiffs' bar been pretty active yet on these issues?
That's a really good question. They really haven't. The number of wage and hour filings is down in 2020 significantly. Some of that may be due to a lot of these matters going to arbitration. But in talking with my plaintiffs' bar friends, they're not seeing a bunch of people come through their doors. They think that employees are happy to have jobs, and they're holding off. But I can promise you that the plaintiffs' bar is trying to figure out a way to mechanize this remote work situation. And so, great. And so we're going to cover a number of areas today with regard to the wage and hour concerns. The one I'll spend the most time relates to that work outside of your scheduled hours and how you control that, working during unpaid meal periods, rest breaks, and then reimbursement of expenses, which is a new concern for a lot of employers, as increasingly we have an increasing number of employees that are working from home. It's interesting, I generally practice with my wife before these presentations, and She did a better job of sort of crystallizing for me what I wanted to say. In general, you can address a lot of these issues with solid policies, training, and communication to your employees. But the way she said it is, it seems like to me, Joe, that you can be proactive with these issues and you can really cut it off at the pass. And that's really what it's about. If you're proactive in developing your policies, revising them, and communicating with the employees, you can avoid some of the larger issues in this area. And so when I think of, most of what I do on a day-to-day basis is class action litigation. So when I think about these issues, what are the issues that could subject your organization to a class action? That's really what we want to avoid. HR departments are built to handle the day-to-day issues, and you can do that within the confines of your policy, but you want to avoid those big class actions. Next slide, please. And so the United States Department of Labor, I think we would say that they got off to a slow start under the Trump administration, but they did some good things at the end of the administration. And one of the things that they did is they issued a field assistance bulletin that's directly aimed at this question of, what do you do with regard to these remote employees and their timekeeping? Employers have gotten good over the years at timekeeping policies and practices, most likely and sadly, as a result of the gazillions of wage and hour lawsuits that have been filed. But I think we're all generally comfortable at this point about what we do when there's a wage and hour issue, in the workplace. And one of the things that we'll do is that if there's an issue, we'll go back and look at the key cards and we'll compare that to the time records, or we'll look at security swipes. What do you do about these remote employees? We don't have eyes on them anymore. We can set a schedule, but are they working? Are they working outside of their regular hours? And that's what this field bulletin addresses. You may be saying, by the way, what's a field assistance bulletin? And that's a really good question. What it is it's a memo that's written by the muckety mucks at the DOL to the folks on the ground who will be enforcing the law, investigating you, talking to you about your policies. And so, remember, it's not law. The DOL under the current administration and how they think these issues should be analyzed. And so remember, we're on the verge of a new administration, so we'll talk about what that could mean as well. And then in this particular bulletin, they did a nice job, if you could, next slide, please, of laying out what the general standard is and then giving you some really good steps to comply with the law. Let's talk about the law generally. And so to take a step back, what are we talking about here? We're not talking about your exempt employees. We're talking about your non-exempt employees. We know that those individuals need to be paid overtime when they work more than 40 hours. And that's the rub here. And so what this bulletin says is that you need to pay employees for all hours worked. That includes those hours that are not requested. And so the field bulletin reminds employers that the onus is really on the employer to exercise control to ensure that employees are working within the schedules and there's not unauthorized overtime. And so it's an easy issue. Let's just say an employee works more than they're supposed to, and they record that time. That's an easy issue. You go to that employee and you say, hey, you weren't authorized to work that overtime. We'll pay you for it, but here's your counseling. Please don't do that. But the tougher issue, and which is really what this bulletin hits on, is what do you do with those employees who are working more than they're recording? I know everyone that's on the panel today, we're shooting emails to each other at 10 o'clock at night. That's going to happen to your non-exempt employees. They will now most likely be responding to emails during off hours unless you nip it in the bud and you address it. And so the bulletin puts the onus on you. And it also says that if you actually obtain a knowledge that an employee is working more than their scheduled hours or off the clock, then you need to do something about it. And so the key consideration then is, what does an employer need to do to show that they've exercised reasonable diligence here so that someone doesn't come down the road and say, hey, you knew I was working overtime, you didn't pay me for it. And so next slide, please. And this is where the guidance is solid and it's easy to follow. What the DOL says is that, hey, you can satisfy your responsibility if you create a reasonable reporting procedure that requires employees to record actual hours worked. You compensate employees for reporting hours worked. That means even when you didn't want it to be worked, you still have to pay for it. And again, I think employers are sometimes hesitant to counsel employees who have worked off the clock. That's exactly when you want to do that. You want to enforce your policy. And then a big issue is you have to make sure that your supervisors aren't preventing or discouraging your employees from reporting hours worked. And so, that seems pretty simple, but this is where it makes me a little bit uncomfortable. And when we think about this field bulletin, remember, you have to think about how your organization runs. And I said that, someone needs to be paid if the employer has actual or constructive knowledge. So what the field bulletin said is it said, hey, you don't have to undergo impractical efforts to find out whether the employee is recording their hours correctly. That's where it makes me a little bit uncomfortable. If you could go to the next slide. Next slide as well. And so there is case law to suggest that the DOL's field bulletin is grounded in law. But these are, and I actually looked through a lot of the cases. I think it's a bit aggressive to say that employers don't need to look beyond the timekeeping, especially when corporations they're relying on reporting more times than not. I know within our law firm, we're constantly looking at production. And so I'm thinking that other employers are doing that as well. So if those production records would bear on whether or not an employee was working more than their scheduled hours, employers really need to keep an eye on it. Don't just turn your head to that. You need to think, and that's the opportunity to nip it in the bud. If you could go to the next slide as well. I wanted to put up a couple cases as well that have said, hey, it's not just enough to require employees to record their time. You actually have to do more. And this is what I'm saying. You have the relevant inquiry is not whether or not you have a good timekeeping procedure. It's whether you have actual or constructive knowledge. And so let's discuss how you can really address this on a more fulsome basis, other than just having a procedure that allows employees to record their time. If you could go to the next slide, please. And I put this California slide in there because, and this is more for Michelle, whenever we talk about wage and hour law, we have to think about California. And so interestingly, there's a Ninth Circuit case that says that, it's enough to put that timekeeping procedure in place and that an employee can't deny the employer the right to know when they're working. But when we talk about California law, you have to realize that most lawsuits out there they're not brought under the the Fair Labor Standards Act, which is what the United States Department of Labor would enforce. They're brought under state law. And with state law, there are a lot more protections under California law than there would be under federal law. In particular, the definition of hours worked under California law is actually quite broader than the FLSA. Under the FLSA, the standard is whether you suffered or permitted someone to work. Here, you could be subject to, an employee is subject to work if they're subject to the control of the employer. So this means that anytime you're under the control of the employer, and there's all sorts of creative arguments you can imagine, even within a remote workforce, where you're under the control of the employer. Next slide, please.
So Joe, let me ask you a question then. What do you think is the right amount of diligence in terms of determining whether employees are working off the clock and recording their hours?
That's a good question, and I think it would depend on your organization. Again, for the law firm who's printing out productivity reports, I think we need to train our employees that, hey, we're going to train our employees and our supervisors. And with the supervisors, we're going to say, hey, if you have knowledge that employees are working more than their scheduled hours, or God forbid, they're working, they're sending you emails at 1 a.m. and you notice that they haven't recorded that time, that is the time to then talk to that employee. But for other organizations, the reporting procedure may be enough. And then here are some best practices, and my understanding is that the slides will be available after the presentation. But when we talk about best practices, again, it's a perfect segue from California. California has its own meal and rest break laws. And so when we're reminding employees about timekeeping practices, we'll also take that opportunity to say, hey, in California, you need to take your meal periods. We're actually going to schedule those for you, and you also need to take your rest periods. And then additionally, you want to issue a written policy, and you want to send reminders. Hey, employees, please record all your hours worked, even if it's outside the schedule. Please log your start and stop time. And really, what that means is that when I defend these cases, I love to see time entries that are uneven. I love when they say 7:51 to 5:47. That's really helps from a defensibility perspective. It is not helpful when we see employees recording straight 8 hours every day. And so that's what we mean with your remote employees. Make it so that they can record their actual hours. It's going to help you down the road. And then also equally important is that let's just take that example of that employee who was working at 1 a.m. Give that employee the ability to supplement and correct their time records. Otherwise, they can't get that time in. And down the road, if you want to defend this payroll policy, you have to show that you paid employees when they requested a correction. Again, additionally, it's okay to mandate that employees obtain authorization before they work the overtime. My favorite language is that, hey, you need to obtain authorization, but we do understand that there may be some situations where you need to work overtime. Please do your best and please communicate with your employers. Again, this is all about communication. Again, train your managers on the policies. Tell them it's okay to discipline. A big one here too is that if you have employees who are complaining about their time entries or being paid enough, work with them, ask them for the paperwork, ask for the proof, work with them. At that point, of course, don't go off and fire them. That happens more times than you would know. And, not only will you potentially have a wage and hour issue, to have a retaliation claim, which are oftentimes more difficult to defend against than a wage and hour claim. Next slide, please. Okay, the next topic is remote worker expense reimbursement. Again, more of us are working at home than we ever have. There are a number of states and jurisdictions that have laws that say you need to reimburse employees for expenses that were required as part of the job. And so what I'd like to spend most of my time here is on, what is required by the job. If you could, next slide, please. And so a perfect example is say, hey, I'm now working at home. I'm using my cell phone. I'm using my internet. I'd like to be reimbursed for that time. And so the question obviously is, well, how much do you want to be reimbursed? As an employer, what the laws say is that you can reimburse employees for a reasonable amount. Unfortunately, that's all the guidance the cases will give you, and that's all the guidance the law gives you. But what it does say is that when you're talking about employee reimbursements, you again want to be talking to employees about what is reasonable and setting expectations for them. The third bullet is a good one. Does an accountant need a printer? I can come up with an argument as to why an accountant would need a printer, but this is where you want to communicate with your employees that, hey, and you can even probably tie it to the environment. Hey, we're going green. We don't want you using paper. You don't need a printer. So under that circumstance, the accountant may not need a printer. If you could go to the next slide. What are some best practices for reimbursement policies? Again, you want to have a very clear policy and you want to send out reminders to your employees. Not all jobs are the same, so define what is reimbursable for a specific position. That will give you the defense to say, hey, accountant, you don't need the printer. Put it down on paper. Then also set reasonable reimbursement limits. Let's just say the accountant went and bought a $1,000 color printer. That's not reasonable. And we want to set these thresholds so that we can rely on our policy. And that's a good point for those Illinois employers. Illinois, unlike California, has a specific provision that says that as long as it's reasonable, you can set the amount that you're willing to reimburse for. It just can't be de minimis. In California, you also want to invite employees to engage in conversation with you if they think they should be reimbursed more than they are. And then you also want to make sure in your policies that you're setting a deadline and a process for submitting those expense reimbursement requests. And then I've answered a number of questions on this from clients, and we've been able to address a number of the expense reimbursement requests by being creative. a lot of businesses have brick and mortar locations that are sitting there idle, but within those locations, there's lots of equipment that the employees can use at home. So if there's a chair that from the office that they can use at home, make that available to them. Next slide, please. And then this is sort of the doom and gloom wage and hour slide. Anytime a wage and hour lawyer speaks, you see one of these slides. But really what this is speaking to is that you shouldn't take these issues lightly, especially on the reimbursement claims, because if you have an unlawful policy, it's most likely going to apply to a large number of employees. And therein is where you run into your potential class action issue. Next slide, please. And then lastly, we just wanted to touch briefly on out-of-state worker concerns. I know that when the pandemic hit, I moved to Michigan for 3 months and I worked there. And I think this is a common fact pattern, but when our employees are doing that, there's a number of things we need to be aware of. Number one, and this was another common sense point from my wife, are they allowed to do that? And that's a really good point. You should be communicating with your employees about whether you'll allow that or not. I would suggest that you be, communicative with your employees from an employee satisfaction perspective, if you can make it work. But when your employees start to work in other states, you have to worry about, are there wage and hour laws from that state that would apply? If your employees move to California like I want to, then they're now under this really employee-friendly wage and hour law that could pay them for hours, overtime after 8 in a day. And I've listed a number of other concerns. The one I wanted to mention in particular was the employment posters, because this is a question we received from a number of employers. And so the idea there is that we know under a variety of different laws, you need to post the various posters under OSHA, under the wage and hour law. And some of those laws and some of the agencies that have enforced those laws relating to the posters have said, hey, it's okay if you make these, make these posters accessible via the intranet or via the internet, but other agencies have not been that clear. So do you really have to post the posters if you no longer have a brick and mortar location? It's a really good question, and there may be some risk there. One practical solution to that is to have your employees acknowledge that they have full access to the posters. And then additionally, if you want to go through the expense, you could send those posters to them. I'm gonna turn it back over to
There we
Michelle.
go. Before we move on, Joe, what about the other way? What about with an employee who usually is working and living and residing in California, and they move to a state that has less favorable employee? Like now they're working in Arizona or Nevada, and they're teleworking from there. Does the law where they're sitting apply, or how do we reconcile the applicable laws?
Yeah, it would depend. I mean, I think that's where you start to you have a crossover between wage and hour, and you have a crossover between payroll tax concerns as well. I think California, notwithstanding the Supreme Court case that's pretty on point on this, that says that if you work within California, within 1 week, then you're subject to the laws. I think California would still try to own you, but I think you'd have a good argument that when you're in Arizona, you're subject to that wage and hour law. I think the bigger concern there is whether you would need to pay payroll tax in both of those states. And some states have reciprocity agreements where you wouldn't have to do that, but other states don't. You would have to pay tax in both locations, and the employer may need to pay tax in both locations.
Great.
In California, we're uniquely possessive over our employees, so you're not getting away that easily just by moving to Arizona for a couple of months.
All right. Well, Joe, I think we're ready to turn this over to Michelle. Michelle, you ready to take it away?
Well, I think we're going to jump into another audience poll question first.
Okay. Here's a question for all of you out there. Since our workforce has gone remote, our employee requests for accommodation and leaves of absence have increased, and stayed about the same, or have decreased? Stayed about the same. Well, that surprises me. Does that surprise you, Michelle?
You know, from my perspective as outside counsel, I can tell you my answer would be that the amount of times that clients are coming to me for advice on leaves have drastically increased. But what I think probably our clients are finding is that the leaves, the requests for accommodations and leaves have remained steady in terms of volume, perhaps, right? But the amount of unique questions and difficult questions that they may need additional assistance on have increased substantially. And I think that's because, especially with the population of clients we're talking to right now, folks who have kept a portion or all of their workforce remote during this pandemic, you're not seeing as many requests for leaves of absence or accommodations that a lot of the employers who are returning their workforce to the physical workspace are seeing. As soon as that happens, we're seeing an influx of requests for leaves of absence or remote work accommodations due to COVID-19. So that part has been carved out. But what we're seeing now are questions for unique circumstances, leaves of absence that no one's ever had to deal with before. And even the most seasoned HR professionals are kind of sitting there scratching their heads and rightfully so, because it's not clear if FMLA or ADA applies, or if any of the host of new COVID-19 specific laws now might apply to provide that employee with a protected right to leave of absence, and whether it's paid or unpaid. So as part of this next phase of our presentation, Joe did a great job of covering the kind of great problem of having employees who are too productive. And now we're going to cover, how to handle employees who are having a difficult time getting that work done for one reason or another. So I'm not going to go through, the diatribe of the FMLA and ADA requirements. You all are well versed in those, but what I wanted to highlight with this slide is the key elements that are going to determine whether an employee's leave request or accommodation request will be covered under these laws. So of course, with FMLA and in California now with CFRA applying to, in 2021, employers with as few as 5 employees, this is going to be a big one. Employees, if they qualify, subject to all of the eligibility requirements, may be able to take a protected unpaid leave of absence if they have their own serious health condition, or they're taking time off to care for their spouse or child or parent with a serious health condition. And so the question that we're seeing with remote workers is whether the condition that's being cited for the leave is a quote unquote serious health condition. So we'll talk about that in a few examples in a second. And with the ADA, the question is going to be, is the condition that the employee is seeking an accommodation for their own condition, or is it somebody else's? And with the ADA, employees are entitled to engage in the interactive process with their employer, and they may be entitled to a reasonable accommodation for their own disability or condition. But the big caveat here, where a lot of requests are not being covered, is that a lot of employees have questions about caring for somebody with a disability or a high-risk scenario, and that's probably not going to be covered under the ADA. Next slide. So in practice, here are some of the more common FMLA examples that I've helped clients with, and so I thought might be helpful to you all today. So if your employee or their family member that they're caring for has a serious case of COVID-19 that's either required hospitalization or has incapacitated that person for several days, more than 3 days, and is requiring ongoing treatment, this is the type of serious health condition that may trigger FMLA coverage. Because again, keep in mind that with FMLA, just having COVID-19 will not in and of itself trigger the right to FMLA leave. Many people are testing positive and may be asymptomatic, or may have light symptoms and still be able to work, or may not have symptoms so severe that they qualify as a serious health condition. And a serious health condition is going to be something that requires an overnight stay at a hospital, or incapacitates that person or their family member for over 3 days, and requires ongoing medical treatment. Another situation we're going to be fielding quite a bit with the remote workforce is when employees or their covered family members have had COVID, or now what's being referred to as long COVID. And these are the ongoing symptoms that employees who may have even had a light case of COVID-19 and been able to work through that may later on have ongoing symptoms that require occasional periods of incapacitation and treatment, which also then may trigger FMLA coverage. So what we're seeing with employees who have had COVID and are now experiencing longer term symptoms are ongoing symptoms like fatigue, cough, joint pain, and in some cases, very serious symptoms related to cardiovascular and respiratory conditions. So we anticipate that we're going to see a lot more FMLA requests along those lines as well. Next slide. So then with the ADA, of course, there's the option to provide leaves of absence as a reasonable accommodation, or alternatively, a reasonable accommodation might not be as severe as a leave. It could be providing a flexible work schedule or other accommodations to permit the employee to continue to work. And so some common examples we're dealing with clients is they're seeing employees who have their own fears, for example, of being high risk due to COVID. And so therefore, they don't want to return to the workplace, or even for remote workers, some of your remote workers may still have duties that require them to leave their home. Unlike me, I've been in my cave for 8 months now, but for so many people, remote work might mean something different. It might mean that they're not coming to the physical workspace, but they are still required periodically to go out to site visits or pick up supplies or deliver something. And so we're seeing requests for accommodations for employees who have some sort of pre-existing condition, or they've been informed by their physician that they are high risk for COVID exposure and COVID complications. And that could trigger the right to an ADA accommodation for that individual for a reasonable accommodation to permit that person to continue to do their job without exposing themselves to COVID. Another very
Michelle, what about an employee whose child has a pre-existing condition, making the child high risk for COVID complications?
Absolutely. That is perhaps one of the top questions we're getting from clients, is that the employee themselves reports to be healthy and fit and able to be out there in the workplace and not at all particularly high risk for COVID themselves, but they have a fear that when they go out, if they do get COVID and bring it back into their home, they have somebody in their house, whether it's their child, maybe they live with an elderly parent, who themselves is high risk. And so they want an accommodation so that they don't have to potentially expose people that they're living with. Under the ADA, the employee will not be entitled to an accommodation by virtue of being associated with or living with somebody who is higher risk. So that's not going to be covered under the ADA, since the ADA covers only the employee's own condition. There are certain protections for employees related to associational disability discrimination. So what that means is that employers are prohibited under the ADA from discriminating against or retaliating against an employee for being associated with, for being the caretaker of a high-risk individual, for example. But the independent right to an accommodation or a leave of absence will not arise under the ADA. Now, that same employee with a higher risk child may be entitled to a leave of absence under FMLA that we just discussed if that child has a serious health condition. So that's, again, we have to check all the boxes and make sure we're not missing anything. One frequent question we're getting is, what about the employee who's asking for, the standing desk, the ergonomic keyboard, the chair that Joe is referring to? You can let people take their chairs from their offices if that's something that's available to them. All of these things may absolutely be accommodations that somebody may be entitled to if they do have a disability or medical note that provides that they need certain accommodations to do their job. And these are new issues that we're running into with a new remote workforce where folks were previously coming into the office and now they have whatever setup they have at home, which may not be as nice. And so from a practical standpoint, first we want to make sure that we're having that employee go through the typical ADA process, bringing in that note to substantiate the need or the limitation, and engaging in the interactive process with that person to determine what what accommodation may be suitable for that person. Now, just because an employee comes to you and says, I need a $1,000 monitor, that may absolutely help them do their job, but there could be, a $100 solution or some other creative solution that equally helps that person do their job. That's not the expense of the $1,000 monitor. So
I like the massage chair.
so do I. My reimbursement request for the massage chair is being submitted as we speak. But so of course, though, the employer has the right to select any reasonable accommodation that permits that employee to do their job. It doesn't have to be the employee's preferred accommodation. Next slide. Okay, so those were the laws, of course, that we've been dealing with now for years and decades. The additional layer of complication for everyone has been that there are these new COVID-19 laws, and specifically the FFCRA, which applies to employers with fewer than 500 employees. This was enacted back in April. Now it feels like years ago, but just April. And it provided a whole host of additional leave options for employees that are actually paid leave options. Ultimately, for employers that are providing FFCRA leave, the leave is reimbursable through tax credits as long as you are collecting the proper documentation and information from employees as you're providing the leave. And we've been working with clients to make sure that they have those systems in place so that come time to pay your payroll taxes, you have the proper documentation with the IRS to claim that credit. So ultimately, in a nutshell, the FFCRA provides up to 2 weeks of paid or partially paid leave to employees for a whole host of COVID-19 reasons, or, and this is the particularly concerning one for many employers, up to 12 weeks of partially paid leave if the employee has a child care issue. And in order to qualify for the FFCRA leave, the employee has to be unable to work or telework due to that reason. So next slide, we'll go through the specifics. If the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19, has been advised by a healthcare provider to self-quarantine related to COVID, or is experiencing symptoms and is seeking a medical diagnosis, that person would be entitled to potentially up to 2 weeks of paid leave, up to certain caps for those reasons. If the employee is caring for somebody who is subject to an isolation or quarantine order or has been advised to quarantine, then that employee would be entitled to 2/3 of their pay. And the number 6 is the 12-week reason. If the employee is caring for a child whose school or place of care is closed, or the child care provider is unavailable for reasons related to COVID-19, that employee may be entitled to up to 12 weeks of leave at 2/3 of their pay. Next slide. So in practice, and keep in mind, the employee must be unable to work due to those reasons. So if that means that the employee can't physically come into the workplace, but they're still able to telework, that employee is not entitled to FFCRA. They'd have to also show they're unable to telework due to that reason. So one very common example that's come up again and again is that employee is symptomatic and they want a day off or 2 days off, to go and get their COVID test and find out if they're COVID positive. So under the FFCRA, that would trigger a right to leave if they are experiencing symptoms and are seeking a medical diagnosis. Likewise, if an employee is exposed to COVID and is advised by a doctor to quarantine, and if they are unable to telework during that time, they would be entitled to FFCRA leave. And I emphasize the "and" because in many cases, right, for example, we'll see an employee has potentially been exposed, they don't have a diagnosis, they don't have any symptoms, but they've been told to quarantine, which just means that they have to stay at home. But if they're already working remotely, they can continue to do so, and they would not be entitled to FFCRA leave.
Now, what about when did we cover this? If they test positive for COVID-19,
yeah,
they're remote, but they're just really, unable to even telework.
Yeah, so that's a great question. So if the employee has gotten their test, they've tested positive, 2 options. If they still feel healthy enough to work and they want to continue to do so, they absolutely can. No FFCRA leave would be provided for just based on the fact that they are COVID positive. If the employee is too sick to work, that's still not a reason that arises under the FFCRA, actually. So if certainly the employee would probably have been advised by a healthcare provider to self-quarantine during that period, and in fact, if they're positive, to isolate. But that in and of itself is not what's triggering that employee's inability to work, right? So if that's an employee who, like everyone on this panel, is able to work remotely, typically, the fact that they've been told to isolate or quarantine is not preventing them from working. So if what's preventing that employee from working is that they are too ill, that will not trigger an FFCRA right to a leave of absence. Instead, that employee may be entitled to leave under your sick pay policy, or maybe entitled to take PTO, or if the COVID-19 becomes a serious health condition, that person may be entitled to take unpaid time off under FMLA. But the fact that the employee is too ill to work is not an FFCRA leave reason. So the perhaps the number one question that's arising from FFCRA is all of the childcare related reasons that people can take leaves of absence. And really here, the key question is, first of all, is the employee's child unable to attend school or their child care facility due to COVID? One very big question here is the child's school open for in-person instruction? Even if the school is open for example, my son has the option to go to kindergarten virtually or in person. And so because I have that option, I've opted virtual, but I can't now use that as a reason to take FFCRA leave. The employee would have to be in a situation where there is no in-person available. So in that first bullet, if the employee's child is going to school in person, but they've been exposed to COVID-19, or like we're seeing in so many schools across the country, that child's class has been told to quarantine because somebody in the class had COVID-19. And so that child is no longer able to attend the school for a period of time, that very well may trigger FFCRA if the employee is then unable to work for that reason. So the second part is that the employee then also has to be unable to work because they are caring for that child during that period of time. So if there's a co-parent or a co-guardian or someone who's typically the child care provider who is available, the FFCRA again would not apply. This is only for a situation where the employee is required to supervise that child while they are home remote learning. So likewise, if an employee typically has a caregiver who themselves is unavailable for a period of time due to COVID-19, maybe the nanny has been exposed and has been required to quarantine themselves, that would trigger FFCRA if the employee then has to be the caregiver for that period of time. So we don't have a webinar long enough to cover all of the state and local laws that have been passed, unfortunately. I wanted to just give one brief example, being out here in California, the California COVID-19 supplemental paid sick leave. So for all of you who, for the last 3 minutes that we were talking about FFCRA, said, I don't have to listen to this, we have over 500 employees. California said, wait, not so fast. We're gonna make sure that your employees have a right to leave too. So California passed a fill the gap legislation, as they put it, for any employer with 500 plus employees. And so if FFCRA does not apply to you and you operate in California, this law will apply. It applies to anyone who is over 500 employees, and for our healthcare clients out there, any employees who you've exempted from the FFCRA who work in California would be entitled to the California COVID-19 supplemental paid sick leave. And the reasons are completely different that an employee may be entitled to this leave. In a nutshell, if you have a fully remote workforce, nobody's leaving their home for any reason to do work, this law will never be triggered. But if you do have employees who are leaving their home to perform work for you, and they've been either subject to a quarantine or isolation order from the government or from their healthcare provider, or for your own policies, that employee is not permitted to do work right now for whatever reason. Maybe they've come into contact and your policy says you can't work during this time. That employee would then be entitled to the California COVID-19 supplemental paid sick leave. So one more factor to keep in mind when assessing whether a law applies. So we've arrived at this final slide, which is really, what do we do though if an employee comes to us, asks for an accommodation or a leave, and we go through our long checklist of laws and none of them apply. There is no legal obligation to provide a leave. And this is happening, in many cases where employees have expressed concerns, for example, about returning to the workforce because they live with somebody who's high risk, or because they themselves feel that they are high risk, but perhaps it's due to not a disability, but their age or something that doesn't quite trigger any of the leave laws that we've just covered. So the key here, from a employment exposure perspective is if employers are, and so many of you are, doing wonderful things for employees to provide additional leaves of absence or accommodations, above and beyond what the law requires, the key is to be consistent, because I think the real potential for exposure here and potential litigation down the road is going to be if we've unevenly provided accommodations for some and not others.
Is that the under the category of no good deed goes unpunished?
That's exactly right, Mike. And I think so many employers have had to scramble with first getting everyone remote right away in March, or sometimes even in February. I think we were remote at the end of February, and then fielding this flurry of requests for leaves of absence and accommodations. And so many of you with large HR teams may have 5-10 different people fielding different requests, and we need to make sure that they're communicating with each other, whether it's an internal policy or an external facing, employee facing policy about what will or will not be approved. It's important to have a uniform policy about how we're going to treat different situations. If one employee is requesting an additional laptop be issued because that's going to really help that person, so they don't have to share their laptop with their 10-year-old who's doing virtual learning. It's wonderful if you want to provide that. Just know that that's setting a precedent. We may have to do that for other people in a similar situation. So we'll just want to make sure that we're tracking all of the nice things we're doing, because exactly, Mike, no good deed goes unpunished, unfortunately, and especially out here in California, just to keep in mind.
All right, well, thank you, Michelle. I think we're ready to flip the switch and turn it over to Emery Moore. Emery's going to talk to us about how we protect our data during this remote work environment. But let's, Emery, before we get started with you, how about we put on this polling question? Let's ask the audience, how important is confidential information to your organization's success? And we've got from extremely important to not important at all. Let's see how our audience responds.
What I thought, Michael.
There you go. Okay, well, that's not a surprise to you, Emery, is it?
No way. So what we know is confidential information is extremely important, and it's often critical in terms of an organization achieving their goals successfully. And what I want to talk to the audience about today is data protection, which I think is an exciting topic, at least to me. And it's something that's often overlooked when we think about the pitfalls that could happen when you're talking about remote work and employees. But there's a sobering statistic that sort of makes this importance known, and that's that 34% of data security incidents are caused by or involve employees. So it's not really just an IT issue so much as an issue of managing employees to make sure data is properly protected. So what we know is failure to adequately protect confidential information from disclosure to unauthorized individuals can have some really serious consequences. For example, imagine you are an employer in an industry where in which competitors bid against one another to win project contracts. Now imagine an employee leaves to join a competitor. Before leaving, the employee downloads data revealing your confidential bidding and pricing strategies. While working for a competitor, of course, the employee can use that data to know exactly how much you will bid and therefore outbid you time and time again. Obviously, over time, that's going to have a huge impact on your business. But again, I think it's important to remember that it's not just your data that's important to protect. So imagine you're an employer in the healthcare industry, and we work with a lot of healthcare clients. Now imagine an employee's laptop is stolen from their car and it contains tens of thousands of patient records full of protected health information. And this is a situation that actually hit the news yesterday. It's happening all the time. So I'm not a healthcare regulatory attorney, but I do understand a little bit about HIPAA, and I know that HIPAA breaches can result in some pretty substantial monetary penalties. I did a quick Google search before this presentation and found penalties as high as $4.3 million and settlements as high as $16 million. So all that to say that this is not a small issue. We should take these things seriously. Whether data gets into the hands of those individuals or outside individuals via an ill-willed employee or an employee mistake, whether the data is lost, whether the data is your client's data or your own data, I think it could have a serious financial impact, whether it's competition, whether it's penalties, or any number of other ways. Next slide, please. One thing we wanted to talk about today was trade secret information. So when confidential information rises to the level of a trade secret, it receives substantially greater legal protections against theft and misappropriation. Federal and state law allow organizations whose trade secrets are stolen or at imminent risk of theft a few different really strong protections. One is the ability to go to court immediately and obtain a seizure order allowing immediate recovery of the trade secrets. Another is a temporary restraining order, and usually you ask the court to prohibit the possessor of the trade secret from using that trade secret or taking any other unfair action. And the third that I think is really important is if something is considered a trade secret, you can obtain up to double the amount of monetary damages as a result of any misappropriation. So we really want things to be considered trade secrets. And this is a rare situation, but if a foreign government is involved, sometimes a corporation may be able to get the FBI involved to protect their trade secrets. And really, again, that's a rare situation, but I wanted to highlight it because it shows that protecting trade secret information is very important. Next slide, please. So critical for our discussion, data will not be considered trade secret if the employer fails to utilize reasonable efforts to maintain its secrecy. So let me say that again, because I think this is a critical point. If you do not take reasonable measures to protect your trade secrets from dissemination to unauthorized individuals, courts may determine that the information is not a trade secret and therefore deny you the benefits of the great protections we just talked about. So bringing this all back to our current discussion, as large groups of employees work remotely and have access to employers' networks remotely, there's a potential for trade secret information to be lost, trade secrets to not be protected as much as they should, and general confidential information loss. So we're going to talk about some steps that employers should take, and we're going to talk about specific issues, but some general steps you should take, especially when we're talking about trade secrets and making sure those trade secrets maintain that heightened protection, includes, for example, ensuring files are labeled confidential where appropriate. We've seen a lot of cases where an organization may say this is a trade secret, and then the court looks and says, well, you didn't tell anyone who accessed the system that it was a trade secret. It wasn't labeled confidential. It was in an open space where anyone could access it. That brings me to the next point. You have to ensure that access is reasonably limited to only those who have a need to access the files. So now more individuals are accessing your network remotely. Maybe they didn't have remote access before. Maybe you've allowed too much access, and you need to make sure that that trade secret or any confidential information is only able to be accessed by those specific employees. And then the third thing is ensuring that employees and others who enter into and others who have that confidential information, for example, contractors or vendors, are entering into confidentiality agreements. or there's a confidentiality policy or some other confidentiality obligation. Next slide, please. I think that brings us to the meat of our discussion. How has widespread remote work due to COVID-19 impacted employers' abilities to protect their data? And what actions can employers take to protect their data? First, remote work has made it more difficult to identify instances of data theft. We traditionally discover data theft upon noticing suspicious computer activity, such as forwarding files to personal email or downloading sensitive data to external storage devices. But as the prevalence of remote work grows, these types of data transfers become more common. For example, employees may forward documents to their personal email for printing on their home computers, or maybe at a local office supply store. They may load confidential information onto an external storage device so they can access it using their personal computer, or again, maybe they want to print somewhere else, or any number of other reasons. Or they may take sensitive files out of the office so they can use those files while they're working remotely. The question is, how do we reduce the amount of static, so to speak, so we can distinguish between bad faith and good faith data transfers? Well, the answer is to put in place policies, as usual, and procedures to limit the instances of employees transferring data outside of the organization's control. For example, employers should consider prohibiting use of personal email accounts for work-related matters. Only permitting use of external storage devices with company approval. And there, I would only grant approval if it's absolutely necessary. Remember, we don't want this data being transferred to devices where we can't track where the data is going thereafter.
So Emery, we can go ahead and restrict employees, say, from plugging in USB devices. But what do we do when they do it secretly without authorization? How do we deal with that?
So there are a number of measures you can take. Some of them are a bit extreme. And I guess three come to mind. One is monitoring computer activity. Another is you can disable USB ports specifically for mass storage. And you can also block personal email sites. With respect to monitoring computer activity, there are really various programs that alert employers to to instances that may raise red flags, for example, large downloads or access to sensitive information that an individual normally wouldn't access in their job.
And that works when we have the employer has a suspicion. Right?
Exactly. So here's the thing, the caveat there. There's software that can monitor as much as you want. It's a bit scary, actually. As an employer, I think you have to worry about not just whether you can legally do it, which you should check state law, but generally you have a right to monitor your own devices as the employer. But I think you should think about the employee morale issues and also public relations issues. And considering those things, I would only employ sort of monitoring software in a very narrow way, such that it doesn't monitor activity all the time. It only picks up certain instances and alerts me. And even more so, I would only use that software if this was really a big issue for me, data theft, or if I had some really highly sensitive information I wanted to protect. Same goes for USB, disabling your USB mass storage ports. It's a drastic measure. Employees need to use their USB ports often, so you should make sure that you can actually do that. As far as blocking personal email sites, that doesn't prevent an employee from taking their work email and forwarding information on, but it does help you so that the employee doesn't have a situation where they log into their personal email and secretly upload files to their personal email, and you have no idea where the data went after that. You can track email in your own system. Next slide, please. So point number 2, when employees work remotely, they are no longer transferring data using the employer's protected internet connection, right? Instead, they're utilizing their own internet connection, or even worse, an unsecured public internet connection. Moreover, since employees are working remotely in unprecedented numbers, the number of different internet connections being utilized to transmit sensitive employer information has skyrocketed. That's that interesting graphic there showing all the different connections. So obviously this gives malicious third parties more opportunities to steal confidential information as it's transferred between networks. So I'm sure you all are doing this already, I hope, If you're using VPNs or virtual private networks, you're encrypting that data, whether it's coming from a personal Wi-Fi, a public Wi-Fi, whatever it may be. If you're not doing that, you probably should. It's very important. But the key thing here is providing VPN access alone is not enough. I think employers need to make sure that employees are actually using those VPNs. I know a lot of employers have VPNs, and it's not mandatory that employees use them. That's really something you work with IT about to make sure that the network or confidential information can't be accessed using non-VPN connections. Employers should also restrict or prohibit employers from using personal devices to access VPNs. When you think about it, a VPN just encrypts data as it moves between the lines. But if the starting point is a personal device that has malware on it already, then it can access that VPN and get into the rest of the system. Next slide, please. A third data protection difficulty created by remote work is the increased potential for loss or theft of devices. Like we talked about, the person having their car broken into and the laptop stolen. The risk of that happening has increased simply because more people are taking devices with them, including a lot of employees who normally wouldn't have access to a laptop or another device they could take home with them. So a great solution here is to ensure that all employees who have access to sensitive information on their devices has data breach protection software. And a lot of you are familiar with this. Mobile device management software is a great tool. And what that does is it permits your IT team to revoke a device's access to the employer's system. And it may also allow the IT team to remotely wipe data from the device. Of course, when we're talking about policies and rules and procedures, again, a lot of it starts with the employee and managing the employee. So it's important that employees be reminded and aware that they have a duty to remind or report these lost or stolen devices as soon as possible, so that IT can take advantage of that software. Another tool utilized by employers is two-factor or multi-factor authentication. I won't go into that too much, but it provides you with, it ensures that an individual who has access to one device doesn't have wholesale access to the system. They need another device before they can access that system. I think another tool that you can discuss with IT department is just simple timeout settings. So if an individual has a laptop and they're in an internet cafe and they walk away, let's say they're away for 2 hours or whatever, or it's at home. You want that connection to timeout at some point so an individual can't pick up and just start accessing data. So fourth, as more individuals have begun working remotely, the chances of employees having confidential information in the presence of family members or other unauthorized individuals has increased substantially. While perhaps innocent, these can be considered breaches of confidentiality and again, may negatively impact your ability to receive trade secret protection. So how do we combat this issue? Employees should be reminded not to discuss confidential matters in public or even around their household members. They should be reminded of any confidentiality obligations already set forth in workplace policies or agreements, as well as it's always important to remind people of potential discipline that could happen if they breach confidentiality. So it's really not a matter of malicious conduct or even careless conduct. I think employees sometimes just forget that they have confidentiality obligations or that the information they're working with is confidential. So they need a gentle reminder. When reminding employees, employers may wish to provide examples of measures to take to ensure confidentiality. For example, employees can be encouraged or required to utilize headsets during Zoom video conferences like we're doing, and that prevents others from overhearing. They should also be reminded that devices should not be utilized by individuals outside of the organization. So if you want to share your laptop with your child, maybe don't share your work laptop. I think another option, and I'll go quickly because of time concerns, is privacy filters. And what those are plastic filters that fit on laptop screens, and they only permit the person directly in front of the screen to view that screen. Next slide, please. And on that point, I remind you about the reimbursement discussions Joe had earlier when if you require privacy filters, document shredders, any other equipment, just have that in mind as well. So fifth, many employers have begun permitting larger groups of workers to use their personal devices to access sensitive company information. When doing that, I think it's important to have a BYOD policy in place. And I think a lot of employers already have these policies in place, but it's important to remind individuals of these policies. And they would include things like we discussed earlier, for example, mobile device management software, or prohibiting use of non-company cloud-based storage platforms. Next slide, please. So with respect to offboarding, I'll quickly say that it's important to keep track of all of your information, right? So that you can have it returned at the end. And what that really requires is that you take an inventory of all devices utilized by the employee. And that includes external storage devices and cloud servers, so that when the time comes, you can request those devices be returned and you know if a device was not returned. Next slide, please. So I'm going to wrap this discussion up with an important topic, which is restrictive covenants, and which includes non-compete agreements, non-disclosure agreements, and non-solicitation agreements. Next slide, please. So we know a few states outright ban non-compete and non-solicitation agreements. Other than a handful, really non-disclosure obligations are generally enforceable everywhere. So when you're talking about enforcing non-compete agreements and non-solicitation agreements, what does that have to do with remote workers? Well, a few different things. Number one, those agreements have geographic restrictions, right? And those geographic restrictions have to be reasonable when in order to be enforceable. Next slide, please. So working remotely allows an individual to be physically present in one location, but direct their work to another location. Defining a reasonable geographic area in the agreement is difficult because they perform work remotely from one location, but the employer is located in a different location. So here, employers can help avoid issues by specifically addressing a remote work situation in the agreement. How that language will look depends on the state laws at issue and the type of work being performed. But as a general matter, the agreement should make clear that what matters is the location to which the work is directed. And there's been a lot of case law over the years over this issue, and courts really haven't decided it definitively. But again, you focus on where is that work actually directed, and you think about it like an employee working, say from Chicago, but they're commuting to Milwaukee. Their work is really being performed in Milwaukee, even though they're in Chicago. It's a really simple issue, but it's given courts a lot of heartburn, and it's just a good idea to have that consideration and look at your contracts. And then the final issue is one that was raised earlier, which is employees, as they begin to move around, can become subject to different laws, and employers, therefore, are subject to those different laws. And we know some states like California may extend their prohibition against restrictive covenants to employees, even if those covenants were originally entered into while the employee was outside of California and only later relocated to California. So it's important to have things like choice of law provisions, venue provisions, but those may not always hold up in court. That's why it's really important to keep track of where your employees are moving and make sure they obtain approval before they move and relocate and to perform remote work.
Emory, thank you. You know, there's some practical issues too that arise during this pandemic environment where everyone's working remote. When dealing with employees who are leaving, say, to go work for a competitor, you know, it's often a good strategy for our local HR person or local manager to sit down with the employee, turn off their connection, you know, to the work site, and sit down with them and question them. Very difficult to do that because once they're disconnected and we're remote, we can't have that sort of cross-examination / exit interview. And if they're not disconnected, they can continue to engage in mischief. A lot of practical issues dealing with, you know, the exit of employees who are intent on violating their non-competes in this environment, don't you think?
I agree. I think that's why it's important to just quickly rethink about how you normally conduct offboarding and different human resources issues before a problem actually does arise. Just think it through ahead of time.
Yeah. All right. Well, we've come to the end here. Thank you very much, Emery, Joe, and Michelle. I think we've got a couple minutes left here. I've got to give some important information, and then if some people stick around, if we've got some questions we can answer, we will. If not, as promised at the outset, we'll make sure we answer questions that you've logged with us, and we'll follow up with you afterwards. So thank you for joining today. CLE evaluation forms along with the slides from today's presentation will be emailed to you shortly. For those of you in New York, the New York validation code is PONY, P-O-N-Y 19, PONY 19. Again, thank you for joining us. Have a great holiday coming up next week. I'm sure every one of you are going to cook something new, and it's going to be delicious. For ongoing updates, please make sure to subscribe to our resource center at mwe.com/coronavirus. Thank you and have a great day.